Still a few more people will probably trickle in here, but we'll get started anyway. All right, we have any requests for bill introductions today? Yep, Randy, go right ahead.
Mr. Chairman, members of the committee, Randy Bowman, Kansas Department of Corrections. Good to see you again, and would ask for your assistance with 23 RS 0568. Just real quickly, what we'd like your assistance with there is changing the name of the Larned Correctional Mental Health Facility to the Larned State Correctional Facility. For those of you who have not been here, the mission changed back in 2016, and the names just never caught up to the current work. So we'd look forward to your assistance with that if we can at the right time.
Sounds good. Committee, any objection to that request? Yep, question.
Thank you, Mr. Chair. I've lost track of the names of the facilities that are at Larned presently. Can you rattle those off from memory so that the security hospital, the state hospital, help me remember what's out there, what those names are now, if you can.
I'll do my best. The only thing for the Department of Corrections now is the facility I just referenced, because we closed the Larned Juvenile Correctional Facility in 2017. And then, yes, the state hospital functions do remain out there too. The security hospital and sex predator program, and I believe there might be one more.
And those are KDAD's operations?
All KDAD's, nothing to do with us, yes, sir.
Thank you. Thank you, Mr. Chair. I certainly have no objection to this fine idea.
All right, sounds good. We'll go ahead and make that request happen. Thank you, Randy. Additional? Bill, yep, go right ahead. Oh, he turned it off. There you go.
It wasn't on, okay. That's a bill dealing with unlawful voluntary sexual relations with the so-called Romeo and Juliet statute.
You have an RS number on that one?
I do. It is 0449.
0449. All right. Committee, any objections to that request? Seeing none, we'll get that one. Next.
My next two are solely from the Judicial Council. There is one dealing with offender registration issues, such as allowing single-point registration, creating a fee waiver mechanism, and extending the existing exit mechanism to certain violent offenders. And that is RS 0501.
Any questions, committee? Any objections? All right. Next.
My final request is a bill that repeals offender registration for juveniles in certain situations, and that is RS 0654.
Questions? Any objections? Got it. I think we got
Thank you.
Yep, thank you. Is there anyone else? All right. Seeing no other bill introductions, we'll go ahead and move into our hearing on House Bill 2031, and we will request Natalie give us an overview.
Thank you, Mr. Chairman. Finally, we have someone doing a request for bill introductions that's my height, so I don't have to change the microphone. House Bill 2031 enacts the Reduce Armed Violence Act to increase the criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involve firearms. The bill amends KSA 216804, that's the sentencing guidelines grid for non-drug crimes, and it would add a new special sentencing rule that when a person sentenced for a violation of criminal possession of a weapon by a convicted felon, the sentence for that violation would be presumptive imprisonment, and it would be served consecutively to any other term of imprisonment that would be imposed if the trier of fact makes a finding beyond a reasonable doubt that one, the weapon the offender possessed during the violation was a firearm, and two, that firearm was possessed by the offender during the commission of a violent felony. For the purposes of this special sentencing rule, a violent felony would include capital murder, murder in the first degree, murder in the second degree, voluntary manslaughter, kidnapping, aggravated assault of a law enforcement officer, aggravated battery against a law enforcement officer, mistreatment of a dependent adult or mistreatment of an elder person, robbery, aggravated robbery, rape, aggravated criminal sodomy, aggravated endangering a child, abuse of a child, any drug felony, burglary, aggravated burglary, arson, aggravated arson, treason, felony criminal discharge of a firearm, fleeing or attempting to elude a police officer, and any felony that would include the domestic violence designation, and then any attempt, conspiracy, or criminal solicitation of any of the offenses above. And I can take any questions.
Thank you, Natalie. I think instead of asking if we've heard this before, we just say Carmichael now? Is that what we're doing?
I believe so, Mr. Chairman.
All right.
So Senate Bill 534 was what this bill was last year over on the Senate side, and it did get out of Senate committee and it died on general orders.
Very good. Questions for Natalie Committee? Representative Carmichael.
Thank you, Mr. Chairman. In reviewing some of the testimony today, I see that one of our conferees appears to oppose this legislation because he believes that violent felony as defined in what he says is subsection Z includes possession of marijuana. Is possession, simple possession of marijuana defined as a violent felony in this statute?
Mr. Chairman, Representative Carmichael, so drug felonies are included here, but for the most part, possession of marijuana is a misdemeanor. It's a B on a first attempt, an A on a second attempt. I think that on a third, it does actually go to a felony,
I
so
think
it's
you're
possible.
probably correct. So I should have just said simple first-time possession of, I'd have to ask the sheriff, less than 2 ounces, something like that. In fact, my town's even stricken that law from the books. Okay, I think that satisfies me. Thank you.
Any other questions, committee? All right, thank you, Natalie. All right, proponents. We have listed first Greg Smith, Special Deputy of Government Affairs, Johnson County Sheriff's Office. Greg, welcome to the committee.
Thank you, Mr. Chairman, members of the committee. Make this real quick. Natalie did a good job of explaining the bill, which explains pretty much why we need the bill. These are people that shouldn't have a firearm, and they do have a firearm, and they continue committing violent felonies. I mean, good news, if you just recently read the KBI's crime report that came out, is that we've had a decline in violent offenses in Kansas for the 2021 year. 2022 stats aren't yet put together. But despite that drop, the number of crimes in 2021 is still 17.9% above the 10-year average. So this is still an issue we have. I know bed space is always a thing that you worry about as a legislature. I remember those discussions well when I was up here. These are the people that need a bed. These are not the people to be letting out early. It's a small percentage of people, and they come back and commit crime after crime after crime. So let's put them away so they can't do it anymore. And I'll stand for questions at the appropriate time.
Committee questions for Mr. Smith? Seeing none? Thank you, sir. All right, now we have Anthony Moe, President, Kansas Gang Investigators Association. And did you want to work with Jamie? I think that's how you guys did it last time. And we'll also invite Jamie Miller, Region 1 representative of the Kansas Gang Investigators Association, for you guys to testify together.
Chairman Homans and members of the committee, thank you for allowing us to provide testimony today in favor of House Bill 2031. We are here on behalf of the Kansas Gang Investigators Association, also known as KGIA. My name is Anthony Moe. I'm the current KGIA president. I've been with the association for 16 years and have been president for the last 8 years. I'm currently a special agent with the Kansas Attorney General's Office after a 25-year career with the Johnson County Sheriff's Office. With me today is Jamie Miller. Jamie is the Region 1 representative for KGIA, and he represents the 17 Northeast counties in Kansas for KGIA. Jamie is a detective with the Kansas City Police Department and has over 18 years of law enforcement experience. We are requesting your support of this legislation today because it fixes a gap we have with our current sentencing guidelines. Sentencing felons to probation only instead of prison time is not the deterrent needed to restore the safe streets that our citizens of the communities in Kansas deserve. Law enforcement continues to combat gun violence in the communities across our state. Career violent criminals are able to threaten violent acts using firearms and avoid prison time due to current sentencing guidelines, even though our current law prohibits felons from possessing firearms. The number of repeat offenders is overwhelming. According to the Wichita Police Department, the number of felons being arrested for firearm possession doubled between 2015 and 2021. I'm sorry, I don't have the current stats for WPD. Numerous people in our state make the conscious decision to carry and use firearms to commit violent crimes even after being arrested for violation multiple times. The need for a second chance for individuals who choose to steer their lives in the right direction is not lost on law enforcement. The law affects only career violent criminals. It is common knowledge amongst the gang community that being caught with a firearm only results on a slap on the wrist, basically more probation. Those individuals who choose to continue to commit crimes and cause violence have taken advantage of the current laws. These career violent criminals will continue to use the system to continue to commit more violence within our communities. As members of law enforcement, we work very closely with criminal street gangs, their families, and their victims. We hear repeatedly that they feel they have to carry a gun, join a gang, or shoot someone because they do not feel protected by the justice system. This may create an entire new generation of people willing to use firearms to commit violence. We need a stronger deterrent. Once word gets out that carrying a firearm results in incarceration instead of probation, we believe the numbers will decrease. As many of us are parents ourselves, we strive for our children to live in a safer society. As law enforcement professionals, we believe this is a significant step in helping achieve those goals. Thank you for your time.
Thank you. Nothing from, you didn't want to add anything?
No, sir.
I mean, you stood up there, so.
Yeah, I'm here to fill in holes and answer questions if needed.
Very good.
Speaker amongst us, so.
Committee, do we have questions for Mr. Moe or Mr. Miller? All right, don't have any at this time. Thank you, guys. All right, next conferee up is Sheriff Jeff Easter, Sedgwick County Sheriff, Chair of the Kansas Sheriff's Association Legislative Committee. And we will welcome him up to the podium again. We've seen you here a couple times. Welcome back.
Good afternoon, Chairman Owens and committee members. I'm filling in for Ed Klump today. He's not feeling very well, so this testimony is from the Kansas Association of Chiefs of Police, the Kansas Sheriff's Association, the Kansas Police Officers Association. Our association strongly support House Bill 2031. It is one of our priority bills for 2023. The bill creates the Reduced Armed Violence Act. The bill is the same as HB 2657 that was passed in this committee in 2022, except for the list of offenses listed on page 10, line 15 through page 11, line 29. The revisor reordered the list, but no crime was deleted or added from what was contained in the bill last year. It also includes the amendment that this committee made to the amendment that this committee made to the bill last year. This bill will make the existing crime of criminal possession of a firearm by a felon a presumptive prison sentence, which must be served consecutively to any other sentence the offender receives if the felon illegally possesses the firearm while committing a violent felony as defined in the bill. Many times the crimes of a felon in possession of a firearm is a presumptive probation sentence, and in other cases the offender is sentenced for the felon in possession of a firearm concurrently with the sentence for a new crime. This effectively means no accountability for the crime of a felon in possession of a firearm. If there's little risk of a longer sentence for the illegal possession of a firearm when committing a new crime, why not be armed? Our whole position, this is, like I said before, one of the bills that we are wholeheartedly behind. We see way too many people that have committed violent crimes. They get probation or they do little time in prison. They come back out, they're armed with firearms again, and they commit another violent crime. With that, I will take any questions that the committee might have.
Questions for Sheriff Easter? Representative Carmichael.
Thank you, Mr. Chairman. Thank you, Sheriff, for being with us again. I hope Ed is feeling better. He was not looking well. Let's just assume that I like to smoke marijuana at my house. And let's just assume that maybe I got a quarter of a pound of it because I like to buy in quantity in order to avail myself of quantity discounts with my local retailer. And let's also assume that, which is a fair assumption, that I like, own, and possess firearms. In fact, you'll find one in my drawer there in my living room. If I have a quarter of a pound of marijuana sitting there on the table, smoking it with my friends, and I've got my firearm in the drawer there of my table, is it the intent that I'm going to go to prison? Is that what this bill is about?
No, it's not. So
Help me.
in your scenario, that would be simple possession of marijuana, which, unless you've been convicted twice before of a misdemeanor, is not a felony.
I thought actually possession of a QP or a quarter pound was a felony. I'll be dadgum. How much?
I can just tell you.
These have changed, okay? Times have changed.
I can just tell you in our jurisdiction, it would be possession.
Okay. So how much marijuana can I have laying there on the table with my gun in the drawer before it becomes something that's going to send me to prison?
I've seen it up to a pound.
Okay, I'll let my retailer know. Thank you.
So basically, now if they're selling it or distributing it to your friends or your retailer gets caught selling it to you, then yeah, that's a felony. If you're in possession with intent or distribution, that's a felony.
And it wouldn't even have to be a sale. Me just giving it to my friends, I suspect, is going to.
Well, there has to be some type of intent to make money also. There's
Oh.
possession with intent.
Okay, I'll let my friends know that too. Thank you, Sheriff.
So, but I will tell you, since we're on the marijuana aspect of this, if you don't think marijuana causes violent crime, it absolutely does. There's 3 homicides in the city of Wichita last year, all directed to the sale of marijuana, and people were killed over that. So it still is a violent crime selling marijuana, even though it's not legal here.
Yeah, and it's also worth noting that we're talking about possession of a weapon by a convicted felon.
That's correct.
So you would already have had to have been convicted of a felony before these additional rules kick in.
That's correct. That's the key.
Thank you, Mr. Chairman. Never mind.
Yeah.
All right. Any other scenario, stories, or questions? Oh, Representative Mon.
Thank you, Mr. Chairman. Sheriff, nice to see you up here. I appreciate you coming.
Yes, sir.
My question goes to the deterrence aspect of this bill. I guess when I've looked at this, serial felons generally aren't too deterred by the risk of going to prison, and I've got no problem with putting them there, but I'm wondering whether you think this would actually deter anyone who's a serial felon coming out and committing another felony with a firearm.
Well, I will tell you, I've dealt with a lot of folks that were hardcore criminals, but in Fed pens, been in the state pen off and on since they've been 18 years old. Do I think it's going to make a difference for them? No. No, they've done 20 plus years here and there. Do I think individuals that that are younger, that have committed a drive-by, committed something like that, it's their first time offense, they are restricted from having a firearm, possibly possessing one again? Do I think it could have an effect on them? Yes, I do. Because as a previous person testified to, they know right now you're not going to get anything for it.
follow up real quick. So, I mean, the person that this is directed at is somebody who's going to go commit another violent felony, right?
Yes.
And that they are doing it with a firearm.
Yes.
In their possession. It just seems to me that if they're intending to commit another violent felony, the firearm aspect isn't going to be a deterrent. But I appreciate the tenor of the bill, and I've got no problem with enhancing.
The big thing that I know the three associations are looking at is believe it or not, sometimes those people get very little time in prison, very little. This is going to cause them to either, what we've estimated, between 7 to 23 more months in prison. That's 7 to 23 more months that these folks aren't out there committing more violent crime.
Sure.
And I know that we're looking at state courts at the moment, but you know, felon possession of a firearm on the federal side carries at least 5 years.
At least 5 years.
Yeah. So okay, great. Thank you.
Very good.
Can I possibly, I don't know if I'm out of order or not, but can I possibly have-
Sure, let me finish, see if we have any more questions for him, then I'll have you come back up. Any other questions for Sheriff Easter, Representative Titus?
Thank you, Mr. Chairman. Sheriff, it's good to see you. So is there any group of, so you have a prior felony conviction, you're committing another crime. Is there any crime you could commit if you have a gun in your possession, but say it's concealed, you never make any threats with it, but the gun was on you, and he or she gets caught on the scene and you catch it? I guess, is there a group of people here that could have the unlawful possession charge, but have not committed a violent felony, or does just having the gun basically put you in all those categories?
So if you're convicted of a felony crime, say it's burglary, and you're banned from having a weapon for a certain amount of time, and they're just in possessing it, yes, that's still a charge of possession of firearm by felon. What this specifically addresses is if you're committing another violent crime. So the other ones that you're talking about would be charged under just simple possession of a firearm. It would not be this statute.
Okay. That would be whether it was on you during the commission of a nonviolent felony, or if you had it at your home and it was found later.
Yes, if you're, you know, if we do a search, just scenario based, if we do a search warrant and say your felony is for burglary, and we recover a firearm that we prove that is yours, it would be under just simple, I say simple, possession of a firearm by felon. It would not be under this particular statute.
Thank you.
Mm-hmm. Any other questions? All right, thank you, Sheriff.
Thank you.
And I believe it is Mr. Miller, is that correct? All right, no, you're perfectly fine.
And
Go right ahead.
something that we deal with on a daily basis in Kansas City, Kansas, is the fact that we run into people that have committed felon in possession and doing a drive-by or committing a violent crime 4 or 5 times in their life, and they're maybe 2 years old at this point, and they've never gone to prison for more than a year and a day, because most of the felony crimes they committed were as a juvenile. So by the time they become an adult, they're starting to get FIP charges or felon in possession charges, but they're getting probation for it. And so they go in, they sit through their trial, then they come out and they go right back at it. With this added in, if they have to go to prison for over a year and a day, 366 days, then they become eligible for federal charges. But up until that point, they're not even eligible in the District of Kansas. So for us to even start considering federal charges against these violent gang members or violent people on the streets, they have to at least have served a year and a day in prison.
Go right ahead.
So is that an issue that needs to be taken up with the U.S. Attorney's Office? I mean, is that a policy of theirs that they won't?
It's actually come down from the courts from Kansas. So the appellate courts say that just because you're convicted of a felony, it used to be you'd be sentenced to your crime, your conviction, and then there would be a minimum sentence and then a maximum sentence, and then whatever you were exposed to for the maximum, even if you didn't go to prison for that amount of time, that's what we went off of to be able to charge someone for felon in possession. But once that hearing came out and that decision came out from the appellate courts in Kansas, then the federal court has to follow that guideline as well. So that takes a level 9 person felony, possession of a firearm, and just gives you probation for it. And that's why we were so excited about this, was because that actually takes, and these guys that are going out and, you know, I can rattle off 10 names right now if you wanted me to on guys that I have arrested myself that are on their 4th or 5th possession of a firearm as a felon.
Thank you.
Thank you.
All right, next up, we have Dustin Carlott, Kansas State Lodge Fraternal Order of Police. Mr. Carlott, thanks for joining us.
Thank you. Chair Owens, members of the committee, thank you for allowing this testimony in my support of House Bill 2031, known as the Reduced Armed Violence Act. I'm Dustin Carlott. I serve as a detective with the Shawnee County Sheriff's Office. I'm currently assigned to the Alcohol, Tobacco, Firearms, and Explosives Task Force as a task force officer. So I've got the unique experience of handling things both state and federally. I have been employed with the Shawnee County Sheriff's Office since 1995, a detective since 2004, and an ATF task force officer since 2021. I offer this testimony representing the Kansas State Lodge Fraternal Order of Police, which is the largest fraternal police organization in Kansas with over 4,200 members. House Bill 2031 would require presumptive prison sentencing instead of the current presumptive probation when a conviction involves an offender that has been previously convicted of a violent felony while in the possession of a firearm. That bridges the gap between probation at the state level. This law would minimum a sentence of 7 months to 23 months federally, with that 366-day that Detective talked about being the minimum standard, along with some other standards for it to qualify for federal prosecution. As a law enforcement officer for over 27 years, it has been my experience that repeat offenders dismiss the legal consequences of possessing a firearm because of the current Kansas sentencing guidelines. Career offenders know the consequences of possessing a firearm at the state level and are just simply willing to take that risk. As a task force officer, I've personally witnessed previously convicted felons whose only concern is whether this case would be prosecuted at the state level or at the federal level. Local law enforcement agencies often depend on the federal government to prosecute these cases because of the stiffer penalties. It is my experience that a large percentage of these cases don't qualify for federal prosecution because of the federal charging standards. This results in a violent armed felon only receiving probation. House Bill 2031 would do away with presumptive probation sentences involving repeat and armed violent offenders. It is my belief this would reduce the number of violent crimes by keeping repeat offenders off the streets. Thank you for this testimony and allowing me to do that, and I'll entertain any questions.
All right, thank you, sir. Questions for Mr. Carlott? All right, seeing none, thank you very much. Okay, we now have Captain Travis Rakestraw, Wichita Police Department, who will be joining us by WebEx. Are you still with us, Captain?
I am. Good
Very
afternoon.
good. We can hear you. Go right ahead.
All right. Well, thank you all for this opportunity. The city of Wichita is a great place to live, work, and play, but it experiences the same violent crime that many large cities experience across the country. While our efforts to stop violent crime continue to evolve, our resources are focused on the most violent offenders in our community. Unfortunately, many who are committing violent crimes within our city involving firearms are already prohibited from possessing a firearm due to past criminal convictions. It is our belief more should be done to hold these offenders accountable for their complete disregard for the law and the violence they expose to our citizens. This is why the Wichita Police Department supports HB 2031. A recent example would be a case that happened early last year. In February 2022, two suspects went to a home and had a dispute over drugs with two other people. One of the suspects, who was prohibited by law from possessing a firearm, brought a firearm with him. During the dispute, the suspect is alleged to have shot and killed the two others he was arguing with. He is alleged to have stolen a gun and other property as he fled the scene. The suspect was charged with 2 counts first-degree murder, capital murder, aggravated robbery, criminal possession of a weapon, and criminal threat. After he was charged through district court, a victim from an unrelated case came forward and identified this same suspect as the person who shot him in 2021. The victim in that case survived, and the suspect has now also been charged with attempted murder in that case. This undeterred behavior is not isolated. In 2022, the Wichita Police Department made 335 arrests for a felon in possession of a firearm. Of the 335, 40 were arrested multiple times for possessing a firearm while prohibited in the same year. Also in 2022, 55 arrests were made for a violent felony, murder, aggravated battery, aggravated assault, and robbery, where the suspect was in possession of a firearm while prohibited. The numbers show that many are undeterred by the threat of our current laws, which they choose to ignore. By passing this bill, we will be holding our most violent criminals more accountable for their actions and hopefully deterring others from ignoring the law and reaching for a gun to commit violent acts in our community. Thank you, and I'll stand for questions.
Thank you, sir. Representative Carmichael.
Thank you, Mr. Chairman. Thank you, Captain Rakestraw, for being with us today. I was listening to this, and it's just not making sense to me. You're saying that we've got felons in possession of firearms who commit violent felonies up to and including murder, multiple instances of murder, and that somehow this sentence enhancement is going to stop them when the penalty for first-degree murder is not sufficient? I'm not tracking. How does, if the penalty for first-degree murder doesn't deter them, why in the world would adding this sentence enhancement somehow change the outcome? And so those people would be alive today. I don't follow. Help me.
I track completely what you're saying, sir. I think more the problem we have is the people that just are completely disregarding the fact that they're already prohibited from possessing a firearm, and they seem to continue to carry it. Like I said, we arrested 335 people last year that were prohibited and carrying a gun. What scares me and what we see so often here is the impromptu violence that occurs that leads to these other crimes. We have road rage incidents. We have simple arguments that somebody who has a gun handy are quick to use it that maybe they haven't put any forethought into. So I think that we do see maybe we can see through the passage of this bill a lowering of some of that impromptu violence that people are thinking twice before they carry a gun when they're prohibited in the first place.
And Captain Rakestraw, you and I can find common ground there, because I agree there are too many people driving around and carrying firearms today, and maybe the cure might be better to go back to a strict concealed carry law like we once had in this state. Thank you, Mr. Chair.
Very good. Any other questions for Captain Rakestraw? Representative Slingensieben.
This is maybe a very general question, and maybe it's one for you too on the committee, but I'm new to this committee. Thank you for your testimony, sir. Thank you, Mr. Chairman. How do we go about assessing the effects that these laws have? Is it by virtue of this process where someone comes forward and says this is just not working for us, as we've been discussing in the case of Senate Bill 367, or do we have some kind of statistical tracking capability that helps us to look at a bill that we've made a decision on and follow it through its career to see whether it is in some way accomplishing what we hope that it will?
I mean, that's a really good question. I know that Scott Schultz is certainly with the Sentencing Commission, tracks all of the data, and we can see that data and see those trend lines based on legislation that we do pass. I don't know that there's anything like a specific report for if we were to pass this that would actually track this specifically, but we could certainly request, for example, that Scott Schultz come back a year later and see, have we had a decrease in the use of criminal possession of a firearm with this enhanced sentence, or how many times has this enhanced sentence been actually applied? That's the data that he would be able to have. Any other questions, committee? All right, seeing none. Thank you, Captain, for being with us today. Committee, I would submit to you written proponent testimony by Brian Wheels, Chief of Police, City of Topeka. I don't have any neutral testimony today for opponents. I have two. Jennifer Roth on behalf of the State Board of Indigent Defense Services. Are you with us on WebEx, Jennifer?
I am. And
all right.
Can you hear me okay?
Can hear you well. Go right ahead.
Okay. Well, I just now see that you'll be able to tell I still have my Christmas decorations up. But at any rate, thank you for allowing me. All right. it does make it more festive. At any rate, I appreciate the committee and Colette's accommodating me because I didn't make it to Topeka after all. But I just wanted to address a couple things about this bill. While we appreciate, I listened to what everybody said, I read their testimony, and while we appreciate the concerns and what this bill's trying to do, we are also concerned about how it covers people who are neither armed in the way that we think of that word meaning, nor violent. And what I'm specifically speaking of there is this idea of people who have committed, who are committing drug possession and have in some way possession of a firearm. And I'm going to talk about an example here in just a minute. And our other concern, as I alluded to yesterday, we're always concerned when judicial discretion is eliminated. Like I said yesterday, just when you think that there isn't a scenario out there where this law wouldn't be appropriate, I'm here to tell you that there is, and I'm going to talk a little bit about that. So those are our two main concerns. But just by way of a little background, and we do provide a lot of this in our testimony, but by way of background, we have a number of special rules that already address some of these situations. And so, for example, special rule number one, first one, the sentencing guidelines are almost 30 years old, and the very first special rule that ever was passed was that if a person commits a person felony with a firearm, it's presumptive prison. We also have a special rule that says if you possess a gun at the time that you commit a drug felony, presumptive prison. People were also talking about how this crime of criminal possession of a weapon is presumptive probation, and that's true for people C through I, if you can picture the sentencing grid right now. But for people who fall into A and B, which is the most severe criminal history scores, it's already presumptive prison for them. We also have sentencing statutes that give judges discretion to already run a person's criminal weapon possession charge consecutively to whatever other felony that they've just been convicted of. And what that means, I realized yesterday, I bet Scott's already talked to you about it, but that means, when sentences are concurrent, that means the shorter ones running at the same time as the longer, and consecutive is when they run one right after the other. So there's already statutes and special sentencing rules within those statutes that would allow, do allow judges and prosecutors to ask for and give the sentences that this very bill is proposing. And so I guess I guess it must not be working the way that the proponents want it to, and thus they're presenting you with this policy choice of making it mandatory to run those things consecutively and to make a person go to prison. And that basically leads to our first concern, which is that whenever you eliminate judicial discretion and impose mandatory minimums, you are going to sweep in people that you didn't mean to sweep in. I know it's hard to imagine that when we hear about these terrible things that are happening in our communities, but I'm here to tell you that there will be people swept in by this that I don't believe this legislature would intend to sweep in. And if you eliminate judicial discretion and make things mandatory, then what that means is that the judge won't be able to decide whether the person in front of them or the situation at hand, whether that's something that warrants concurrent sentences or maybe a person being put on probation. So we are very concerned whenever you take away the safety valve of judicial discretion. And I guess I was thinking a little bit about some of the examples that Representative Carmichael and Representative Titus mentioned. And so, for example, when I said that a person could get swept up in this law if they were not armed and not violent, I'm thinking about people who have guns in their home. And they're not supposed to. I mean, right, this doesn't kick in unless you are a felon who is prohibited from having a weapon. But let's say, even so, I have a gun in my house, and I also have some sort of prescription drug that's not mine. So I'm committing felony possession, and I have a gun in my house when I'm not supposed to. That's a person that could be covered by this. If I'm a felon and I'm not supposed to have a gun, and I have one in my house, and I know it, which I guess now I should interject and tell you, that possessing something doesn't mean that it's on your person. It could be in the trunk of your car, it could be in your basement at your house. But if you're committing a drug felony of possessing a drug that you're not supposed to have, and it's a felony to possess it, and if you also are not supposed to have a firearm and there's one in your house, your car, or on your person, that is a scenario in which this person would get swept up. And the other thought I was thinking about when Representative Titus asked his question was this idea of, all right, let's say I'm in my house. I'm not supposed to have a gun because I'm a felon and I'm not supposed to have a gun. But in some way, somebody comes and attacks my house or something, and I overreact and whatever. I commit an aggravated battery and my self-defense claim is not successful. That's another person that's going to be swept up in this. Is that what we wanted them to do? No, maybe, and it's illegal, but they will be falling under this. And again, I don't know if that's a person trying to defend their home, even if they shouldn't have that gun, if that's a person that you want to send to prison for an extra 17 to whatever number of months it is, at the cost of $37,000 a year. And I guess the final example I would just leave is the one that's in our testimony, that we, in Missouri, they have, like even Kansans who've gotten these things in Missouri, or people in Missouri, they get these things called suspended imposition of sentence. And normally in Missouri, those aren't convictions, but in Kansas, our appellate courts have said that they are. And so we would have people who would drive across State Line Road. And again, do I want people to have felony possession of drugs and have guns in their car? No. But is that really the person that we want to have this law encompass? And I would suggest that it is not. And so if this committee decides that this is the policy choice that you want to make to do this, that you would at least consider removing felony drug possession from that list of violent felonies. And again, we would always urge this committee to leave some sort of safety valve in place so that a judge can exercise discretion. And I'm sorry, I'm just looking at my notes, make sure. I just wanted to tell you one other thing. It very much is drug distribution when you give it to your friends for free. So at any rate, just FYI. And so that's another scenario here, right? Is if I'm a felon in possession, again, do I want people to have guns and drugs and things like that? I don't. But what we are here to decide is who do we want to get, who do we want to target with this law? And if you, I guess I'm just urging that you would narrowly tailor it and consider removing some people from the net that it would cast. So thank you for your time, and I'm happy to answer questions.
All right. Thank you, Ms. Roth. Questions? Representative Vaughn.
Thank you, Mr. Chairman. Ma'am, you referenced the judicial discretion not to impose these sentences. Is it your reading of this proposed bill that it prohibits a judge from departing downwards under this proposed act?
You are reading my mind. So I struggled, and I talked to my co-chair of our committee, and I said, the way I read this, I'm not so sure it doesn't permit a departure as far as being able to depart to probation. And so I guess in the abundance of caution, we talk about this in our testimony as though it does. But I'm with you. Here I am spilling my secrets. It's not really a secret though, but I agree that the way it is currently worded, I think there probably is still a possibility that a person could ask for a departure to probation. They would not be able to get around the consecutive sentencing, however. But I do agree that I think that's possible. But my concern is that I want it to be perfectly clear that a person could ask for that. But thank you for the question and the opportunity to address that.
I just wanted to follow up. I know we've got members on the committee who aren't necessarily used to these terms of departure and everything. I just wanted to kind of clarify that a departure is when counsel on either side asks the court in a written motion to depart from the presumed sentencing guidelines. So, so if the presumption is prison, the court generally does have the discretion to not follow that presumption under certain circumstances. So I don't mean to be condescending to those of you who do understand, but I didn't know whether everyone got it.
Fine. Thank you. Any other question for Ms. Roth?
Can I just could I just address that as well really fast?
Sure.
Okay. What I was going to say is sometimes it's not even just the defense who's asking for a departure. Sometimes we have an agreement, like part of the plea agreement is that the prosecution will also recommend a departure. And that can help everybody because it's going to give the defense a chance to say, well, the state agrees. And it also is a chance for the state to get the plea agreement it wants, to get the convictions it wants. And so I didn't make this point anywhere else, but this idea of judicial discretion and people being able to tailor sentences in ways that are appropriate, that helps the prosecution as well as it helps us. So I just would throw that out there.
Very good. Any other questions for Ms. Roth? All right. Thank you very much, ma'am. Next and final opponent is Nick Reinecker, private citizen. Welcome to the committee, Nick.
Thank you, Mr. Chairman, and the members of the committee for allowing me to speak today. I enjoy the office of the sheriff because it's kind of like where the buck stops here, no matter what legislation there is. Because apparently in the county part of Sedgwick, you can have a pound of cannabis on you and a firearm, and not only will he not take your firearms away according to federal law because you may be a user or addicted to controlled substance, but it's not a felony until it's a pound. And I do have some pushback on the idea that the drug is the problem and not the prohibition. I think the prohibition is actually the problem more than the actual drug itself. So let's say in 2003, did I introduce myself? Nick Reinecker, Inman, Kansas. Private citizen. I'm not a doctor, a lawyer. I'm just an engaged citizen. Been coming up here for the last 10 years advocating for constitutional cannabis. And I would plead that you read my testimony attachments and fact check it with the Constitution, because for the new people in here, you are new legislators in the best system of self-government that we have, even though it's messy. Be constitutional, forgo peer pressure, and don't violate those principles. And philosophically, I think the root has been ignored, and we're dealing with the fruit. For too long, we've been soft on crime. We've called it mistakes or mental illness or substance use disorder as defined by the Diagnostic and Statistical Manual for Mental Disorders, when maybe what we need is moms and dads who use the rod to comfort and love to heal. But this bill deals with sentencing guidelines. And I noticed in section 1 here, it says, A, the provisions of this section shall be applicable to the sentencing guidelines grid for non-drug crimes. And so when I go down the list of all what's being defined as a violent felony, and I'm reading all these and I'm like, yep, that's cool, that works, yep, murder, sodomy, abuse of a child. Well, then we get to N, and it says any felony offense of a drug crime. So I don't really understand how, you can kind of reconcile that. And so I get to my scenario, say back in 2003, you have a firearm on you at your house, and you are growing some cannabis. An appraiser comes by and sees what you're doing and alerts the authorities, and you end up getting a felony because you're growing cannabis and you have a firearm on you. Well, let's say you don't get an expungement, or 10, 20 years down the road, your mom has cancer and you get a couple of vape pens for her, and you get a simple possession of cannabis and this, like, it happens more than once because you're taking care of your mom and you don't want to use synthetic medications or anything like that. And the third time, you happen to have a firearm on you, the smell of cannabis, non-constitutional sheriff decides to enforce the law that you put into place, and now you are subject to this special sentencing rule. And so that is mainly the biggest problem that I have with that. And last year, when I testified, then Attorney General Derek Schmidt said that he didn't even believe that possession crimes were on the list. And you can take a look at that. It was from February 15th, 2022, in this same committee. So, you know, I could go into commentary, but I do have some issues with that as it stands. And I was frantically writing notes while everybody was talking. I put the 215706 in there in my testimony, and then, you know, whether we talk about workforce shortages or child welfare or behavioral health crises and whatnot, how Missouri is handling what they just changed in their Controlled Substances Act. But those are the main issues that I have with this bill, and I thank you for allowing me to speak, and I will take any questions that you have.
Committee, any questions for Mr. Reinecker? Representative Carmichael.
Thank you, Mr. Chair. Mr. Reinecker, I find myself agreeing with you first on the admonition, be careful about possessing a pound of marijuana and then wrapping it up for Christmas presents and giving it to all of your friends, because I suspect that probably is a felony. So I appreciate that admonition. And secondarily, I also appreciate your correct remark that it's not the marijuana that occasions the violence, it's the criminality, the prohibition of marijuana, and the inability to enforce contracts in the civil courts that results in self-help remedies, people with guns enforcing their own contracts and agreements. But Mr. Chairman, what I really wanted to point out is, I think on this bill, as well as I believe the next one, we do not have a bed impact statement. And before we work this bill, I think it's extremely important for us to take a look at what the projected impact is on bed space and the cost of that. And so I hope you will defer until we get that information. Thank you.
That information was emailed out. Everybody should have gotten it. It wasn't part of this email set, but it did come directly from the Sentencing Commission, and I actually forwarded it to Colette to request that she start adding those in with the daily set.
So I should have an email from Mr. Schultz on this?
I believe it's the assistant over there. Hold on one sec. It is from.
Just help me with the time or something, and that'll get me the right place.
It's from Brenda Harbin. She sent it out, it looks like Tuesday, the 17th at 1:39 p.m.
Okay, I will look for it, because I just look for Colette's good work, and I apologize to Ms. Harmon if I overlooked her email. Thank you.
No problem. Any other questions, committee? All right, seeing none.
Thank you.
Thank you very much, everyone. I don't have anybody else listed for testimony. Was there anybody else in the audience that wanted to speak? All right, seeing none, we'll go ahead and close the hearing on House Bill 2031. Thank everybody for coming. And now we'll move on to House Bill 2071 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2071 makes changes to terminal medical release from the custody of the Secretary of Corrections. Under current law in KSA 223729, the Prisoner Review Board, upon receiving an application by the Secretary of Corrections, can approve an application for terminal medical release if a doctor has determined that a prisoner has a terminal medical condition and is likely to cause death within 30 days. This terminal medical release is subject to revocation if the prisoner released does not die within that prescribed time period. And the bill changes the number of days that that medical condition is likely to cause death from 30 to 120 days. And I can take any questions.
Committee questions? Seeing none, thank you. All right, we'll now call on proponent Scott Schultz, Executive Director, Kansas Sentencing Commission. Welcome back, sir.
Thank you, Mr. Chair, members of the committee. Kind of have to switch gears here after a pretty heavy subject on that previous bill. This is also a pretty heavy subject as well, except we're in a, right now this kind of takes us into a situation where we have an individual that has a terminal illness and is incarcerated. And this is being brought by the commission. This was a brainchild from Representative Heiberger that he brought it to the commission, and they unanimously approved it. Last year's bill, 2021 HB 2031, you passed it out of the House 96 to 29. I kind of wanted to just start with a quote from Dr. King. He says, "An individual has not started living until he can rise above the narrow confines of his individualistic concerns to the broader concerns of all humanity." And that is kind of apropos for what we're talking about in this particular bill. We have certain individuals that most of you obviously have either had family members or friends, at least, acquaintances that have had terminal illnesses, and that how having family comforting them in the final days of their life is something that is very important when they are looking at the end of their days. This particular bill is set to essentially secure release for those individuals with terminal illnesses that are incarcerated and have basically been given a certain number of days to live. The current law is 30 days. So this is already on the books. DOC actually takes applications from these folks. The flaw in this particular legislation is that it's only 30 days. And the only thing that you see throughout that bill is we've changed it to 120. Why? Because the process itself takes about 30 days. So most of those individuals that would possibly be able to apply will never make it to the end, or even if they actually do get their request granted. Part of this is also comes from the fact that prisoners who are older that experience serious medical, cognitive, and mental health conditions, and those, of course, with terminal illnesses, not only cost the system and DOC more, but they actually are less likely to be rearrested or recidivate. And so in my testimony, I actually have Department of Justice actually did a study of federal prisoners receiving compassionate release under federal law. They found the recidivism rate to be 3.1%. So very, very low on those individuals that would actually, when released, would actually commit more crimes. A handful of states currently have 30 to 60 days as a time period when they could apply for compassionate release. One of the articles that I've actually attached or linked in my testimony has Kansas as one of the most extreme examples of actually on the bottom end of how we actually treat folks. And so at 30 days, it obviously is virtually impossible for a prisoner with a short time to live, to survive long enough to actually be released and be with their family. So part of the issue, there are already In addition to the terminal illness in statute, there are already 7 other factors that DOC has to consider. So that's obviously a backstop as to they just don't have to have terminal illness and they're all good to go and we can open the doors for them. There are 7 other factors, and that actually is located in the bill for your review. Things like the person's age and personal history, their criminal history, the length of sentence and the time they've served, the nature and circumstances of the current offense, the risk or threat to the community, so public safety, and whether an appropriate release plan has been established. So DOC is covering their bases here in terms of whether or not release could actually occur. My final point would be, for those of you obviously concerned, while we talk about the grid sentences, and I've talked to you a lot about that the last couple of weeks, off-grid individuals, those individuals who have received life sentences, are not eligible under this law. So don't worry about that. Anybody that's child sex crimes, murder, those type of crimes that have received life sentences, they would not be eligible for compassionate release, just for those folks that would be on the guidelines. So with that, we think that certainly 30 to 120, that even that, I think we had discussions about up to 6 months. But think about those situations as far as our own humanity and how we would like to live out the last parts of our days if we actually were terminally ill. I'd like to have it with my family, obviously. With that, I'd stand for questions.
Thank you. Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here, Scott. My memory is that most states that have a terminal release program have their date set at 6 months. Is that accurate?
I believe that's the average or higher. Even with this bump, we'd still be in the bottom, the bottom as far as the time limit. And keep in mind, and Representative knows this as well, if something does happen, DOC can actually pull them back in and revoke them. So this isn't just a free-for-all type of situation. They still have supervision, and if they wouldn't comply or do something to be revoked, they can actually be pulled back in after they're released.
All right. Yep. Representative Butler.
So, Mr. Chairman, and thank you. And just a question on the time. So the 30 days, and I think it said if they at the end of that 30 days, someone terminal and they've not passed, they can be reincarcerated at that point. Is that the way I'm understanding? And then if they are, then they go back through the process again. If it stayed at 30 days or 120 days, they would go back through the process again, and because time is held by somebody else's hand. So it's just, things could change. So how does that work?
That's, yeah, if you look on page 1 of the bill going into the second page, the board has those conditions, and they can be revoked if the person's illness or condition significantly improves, they don't die within that period, that 30-day or 120-day of release, fail to comply with conditions of release, or they conclude they're a potential risk or public safety. So there is a mechanism in statute for that to actually occur if they live outside the time period of what the doctors have indicated.
So just to follow up, so can they extend it once if they're out there on that period of time and they have not passed at that time? Can it be extended, or do they have to be?
I think going forward, if you look at the next section, it indicates that the person can remain on release until the release is revoked, or their maximum sentence expires. So you're asking all the right questions, obviously.
Representative Heiberger.
Thank you, Mr. Chair. It's my memory that KDOC initiates the petitions for terminal medical release. Is that accurate?
Yeah, that would go to DOC. Actually makes that determination. What I would indicate too, and it's in my testimony as well. We went back and asked DOC, with this change, what would that look like as far as individuals being eligible? They have indicated that they estimate 9 to 10 people per year would be eligible for consideration, not necessarily granting the application, but be consideration for terminal medical release. Just to give you an idea, under current law, They see somewhere between 0 to 1 application per year. And between 2016 and this year, there's been only 1 application in 2016 and 1 in 20. So two applications have been granted during that time period.
So this is more of a comment, though. So it's just speculation on my part, but it seems to me that someone had been released on this program and came back either through timing out or for some sort of violation, that the KDOC would be unlikely to initiate a second petition.
Very good. Representative Slinger-Stephen.
Thank you, Mr. Chairman. Why is it that we're asking for 4 months in this bill rather than the national average of 6+? Are we dipping our toes into this gradually? Or 6 months, I know, in the hospice setting is often the amount of time that one sort of presumes that someone might still be alive and therefore be eligible for being received into a hospice home. Of course, these things, doctors aren't sightseers, and you never know what the body's going to do. So I'm just curious where the 6 months comes in. And
how about we let Representative Heiberger, because he's worked on this for years.
I'll jump in this because I initiated it. The first proposal was 90 days because that's as high as the Sentencing Commission was willing to go the first time we proposed this. Somebody in corrections other than myself offered to raise it up to 120, and that's where we've been at. I think 6 months is more reasonable, but I'd like to see us do something rather than shoot higher than we can achieve.
Very good. Any other questions? Representative Smith.
You know, I find in this conversation sometimes, since last year, often people listen to, I have 3 to 6 months to live, right? So that seems like they have a guarantee of at least 3 months, but normally what a doctor is saying is it is likely, and that's the term they use in this statute, likely that they will die within that amount of time, not that they will last that amount of time. So when you take it in that context, or when I take it in that context, I see it more of, the body is going to break down in this amount of time, and if it doesn't, it will be likely shortly thereafter, you know. So I think that's the context that I was able to digest it a little better and understand what is the likelihood that an individual will extend their life beyond that. I can't imagine it being very measurable. So,
very good. Any other question? Representative Carmichael.
Thank you, Mr. Chairman. And I'm not sure if this is for Scott, but maybe for my learned colleague who's on the panel. When someone is in the custody of the Secretary of Corrections and they fall ill, whether it's a terminal illness or otherwise, Department of Corrections pays for their medical treatment. I think when somebody passes away in the custody of the Secretary, that unless someone else steps up, perhaps the OC pays for internment. I see a nod from Mr. Bowman. Have we given any thought? My guess is if people are out on compassionate release, they no longer receive treatment through DOC, and DOC doesn't come and bury them. I just want to make sure I'm kind of on track of this. If you take advantage of this, you may lose your hospice care, it seems like. Does anybody know if that's how this works?
Randy Bowman, one
I
of
will
our
defer.
regulars from KDOC, is more than welcome to answer. We are
I'm not
here-
necessarily saying that's bad. I'm just trying to figure out what the ramifications are.
I just think it's important that we vet these questions and we find these answers, so this is good. Thank you, Randy.
Randy Bowman again, Kansas Department of Corrections. Thank you, Representative, for that good question. That's a little bit of the dilemma for the Prisoner Review Board in reviewing those on the 7 criteria is, can they have someplace to go and get care and treatment when we let them out? And I know that sounds very peculiar, that would be a factor to us, but it is a question for these that does factor in. If they may have no medical coverage, sometimes no family who can help out, are factors. Yeah.
And so if there's still anybody in the Secretary of Corrections custody who actually has their own assets somewhere, they're going to be able to make arrangements for medical care, a nursing home, hospice care, but probably if they're indigent, like most inmates, unless they have family who's willing to foot the bill, it sounds like they stay in custody generally.
generally that would seem, that is one of the barriers, is we can't
One of
find
the
care for
many inequalities in our economy, or in our country. Thank you.
Representative Turk, did you have a question? Perfect. Any other questions, committee? All right, there we go. Thank you very much. Thank you very much, Scott.
Thank you.
All right, we'll now turn to Jennifer Roth, who I believe is still on WebEx with us, and turn the time over to you.
Thank you. I know you all need to get moving, and so I just wanted to make a brief comment. As I mentioned yesterday, we are now coming before you as part of a legislative committee of the Board of Indigent Defense Services, which is our public defender agency. And we, as you probably heard, we represent, either we or our agency through working with appointed counsel, we represent 85% of people, of adults charged with felonies in Kansas. And it is our mission. We got an official mission statement last year, and it is our official mission. A part of that is that we strive for dignity, and that we are to champion people's human dignity. And so I just wanted to appreciate what Scott had to say and how he said it. I appreciate Representative Heiberger and the Sentencing Commission for taking this on. When we recognize people in their humanity, it does not undo any sort of suffering that maybe they had caused at some point, but recognizing people in their humanity and working and showing mercy to people is what we should be striving for. So it is consistent with our mission as BIDS, and so we would ask you all to support this measure. Thank you.
Thank you. Questions for Ms. Roth? All right, seeing none. Thank you very much. I do not have any neutral or opponent testimony, and I don't, if there's anybody in the audience that would like to speak. I didn't think so, but wanted to ask anyway. Very good. So we'll go ahead and close the hearing on House Bill 2071. Committee, what I'm going to go ahead and do is, unless somebody objects, I really don't want to rush through working our first bill and having only 9 minutes till the end. If there's no objection, we'll go ahead and move that till tomorrow's agenda. Okay, very good. So we'll move that final action to tomorrow, and we'll be adjourned for today.